Hello everyone and welcome back to another episode of Business Law. Today we're going to be covering patent law.
You want me to say it with you?
Alright, well, let's get right into it.
What topics are we going over?
So we are going to be going over the introduction, of course, what may be patented, what may not be patented, basic requirements for patents, patent trolls, which is exactly what it sounds like. And of course, as always, key takeaways. Okay, so what is a patent? A patent is a government-granted right that gives an inventor the exclusive ability to prevent others from making, using, or selling their invention for a set period of time.
So, copyright.
Different.
Oh.
And we'll get into that.
Okay.
Patent law was enacted by Congress in the first article of the Constitution, which the quote is from Brother Hales: a patent gives an inventor the exclusive right to make, use, and sell an invention for 20 years. Patents protect the products from being used without permission. What may be patented? A patent is a process, state of the art, which means the most recent stage in development of a product incorporating the newest technology, ideas, and features, machine, composition of matter, or distinct usage. A manufacturer is an article of a product like a television. Genetically engineered organisms may also be patented, like bacterium for digesting crude oil and oil spills fought over Diamond versus Chakrabarty in 1980, which was fought in the Supreme Court. Art cannot be patented because it must be copyrighted. Does that make sense?
Yeah, so patent is like the other form of like protection.
So
Besides, not copyright, but it's like kind of similar but different.
copyright is for like intellectual property.
Like a song,
So like
or a movie,
like
or
a
a
song,
book.
art, book, movie, but like a logo.
That's patented.
I'm trying to think actually. Yes. Okay, at any rate,
Moving on.
what may not be patented. Laws of nature and natural phenomena, as well as abstract ideas, cannot be patented because they merely exist, according to Brother Hales. An example given by Brother Hales is software that was disputed because code is made up of mathematical equations, which is a natural law of nature. Although math is a natural occurrence, the Supreme Court ruled that patents could be obtained for software if the process of coding and developing was patentable. As in, you're not just patenting math. You're patenting the usage of in a software.
Okay.
Business processes can be patented as well, like Amazon's one-click system, which is a system of, processing credit cards securely with one click.
Okay.
Basic requirements. For patents to be used, several requirements must be met. 3 outlined in this chapter are: 1, the invention must be useful; 2, the invention must be novel or new; and 3, the invention must not be obvious. We'll just wait a second. Basic requirements, that's what we just covered. Now let's talk about the aspects that we just talked about. So number 1, the intention must be useful. This is a hard determination, but a question might be asked: is this invention useful to somebody? Pretty straightforward. The invention must be novel or new. The law states that an invention must not be patented already, or that the public has not already been using it. An example is like the Fine Brothers from YouTube. Do you remember Kids React?
Yeah.
or things like that. They tried to get a patent / copyright. I think it was a patent. They wanted to get a patent on reaction videos.
Did they?
Nope, because it's
All over.
like it's done. You can't do that. The invention must not be obvious. The USTPO determines if an invention is different from prior inventions, known as prior art, the level of ordinary skill. Procedures for researching and obtaining a patent. The first step is to determine which patent is needed. The two patents are utility patents and design patents. Utility patents are the most common types of patents in the United States. A utility patent is granted for a useful, innovative item or process or an improvement to an existing item. Utility patents involve a machine or composition of matter. Design patents, these protect the appearance of a product and is a visual ornamental characteristic, not a functional one. For example, a Coke bottle, like a glass one, got a design patent for its unique shape and details. That's not because of, those aren't there because of function, they're because of they want to look good, so that's why they can be patented. Now let's talk about the last topic before our key takeaways, patent trolls. What do you think of when you hear the word trolls?
Like someone online that's pranking you or just being dumb.
Yeah, now think about that, but in terms of patents. So they're kind of just like harming, causing mischief and mayhem. So a patent troll is a company typically that buys cheap or obscure patents and demands companies pay them money in order to stop them from infringing on their patent. So like for an example, if a company is using something that has a patent but isn't being enforced, this troll will find that patent, buy it for really cheap, and then use it to sue that company. Like, hey, you have our patent, or you're using our product that we have a patent for. You either stop using it or pay us a lot of money. And typically they just would want to pay money. So very interesting. I didn't know about that.
We should get into that business.
We should. Which brings us into
key takeaways.
So, famous patents: the television system, the hoop toy, also known as the hula hoop, telegraphy by Alexander Graham Bell, the television system, which I already mentioned, I guess. And let's talk about interesting patent cases: Apple versus Samsung. This high-profile case involved a series of lawsuits filed by Apple against Samsung, alleging that Samsung smartphones and tablets infringed upon Apple's design and utility patents. The legal battle spanned several years, with both companies winning and losing various claims. In 2012, a jury awarded Apple over $100 billion. Just $1 billion. $1 billion worth of damages, but the amount was later reduced on appeal. Now let's talk about the one we talked about earlier. Diamond versus Chakrabarty. Amanda Chakrabarty, a scientist at General Electric, submitted a patent application for a genetically altered microbe that could degrade crude oil in this significant case in 1980. The U.S. Supreme Court ruled that living organisms could be patented, setting a precedent for the patentability of genetically engineered organisms. Very interesting, right? So this chapter coincided with the U.S. Constitutional History / Law class again that I'm taking, as we talked about the Supreme Court's rulings in that class, and what is and what isn't constitutional for them to step in on and rule over. But since patents are outlined very clearly in the first article of the Constitution, the rulings for certain cases like Diamond versus Chakrabarty are interesting to read about. In this class, we've been deciding about overstepping bounds, and like I said before, I believe that Diamond versus Chakrabarty was constitutional, and the Supreme Court were acting within their bounds. So thank you guys so much for watching, and we'll see you guys next week for week number 9.